The legal check was routine. The kind of administrative review you run periodically on your intellectual property portfolio. Not because you expect to find anything, because the discipline of checking is part of protecting what you have built. I was running through the filings on a Tuesday morning. Standard process. Nothing urgent about it. Until I found the patent. Our product. 2 years of joint development. Equal contribution. Equal sacrifice. Filed 6 weeks earlier while I had been away for a family emergency. Marcus's name on it. His name only. Not the company. Not both of us. Just him. I read it 3 times. Then I picked up the phone and called him. His explanation was immediate. Administrative error. He had always planned to transfer it to the company. It was just a timing issue. Nothing to be concerned about. He said it with the specific fluency of someone who has prepared an explanation for a question they knew was coming. I thanked him, said I would look into it, put the phone down, and call my lawyer. But to understand why that call changed everything, you need to know what 2 years of building together actually looked like. Marcus and I met through a mutual contact in the industry, not at a networking event, not through the kind of arranged introduction that produces a polished first impression designed to sell, through a genuine conversation about a shared problem that neither of us had solved yet. That origin matters, because the partnerships that work tend to start from something real, from 2 people who have independently identified the same gap and who discover in conversation that their different approaches to addressing it are complementary rather than competing. That is what Marcus and I found in each other. He came from a technical side, deep expertise in the underlying mechanisms of what we were building, the specific kind of knowledge that takes years to develop and cannot be shortcut by intelligence alone. I came from the application side, understanding of the market the product would serve, the clients who would use it, the specific problems they needed solved, and the form those solutions needed to take to be genuinely useful rather than technically impressive but practically difficult. Those 2 things needed each other. The technical depth without the application understanding produces something that works in theory and struggles in practice. The application understanding without the technical depth produces something that identifies a real need and cannot adequately address it. Together we had what the product required. That complementarity was the foundation of everything we built. We formalized the partnership carefully. A co-founder agreement that defined equity, responsibilities, decision-making, and intellectual property ownership clearly. Everything developed during the partnership would belong to the company jointly, not to either individual, to the entity we had created together. That clause was standard. Expected. Neither of us questioned it, because neither of us had any reason to. We were building something together. The thing we built would belong to what we had built it for. The first year was the year of conception and iteration. The product existed as an idea with genuine potential. Making it real required the particular sustained effort of 2 people who were willing to work at a problem for longer than is comfortable. Long enough that the early versions that don't work teach you what the next version needs. Long enough that the thing starts to reveal its own requirements through the process of attempting to build it. We worked through those iterations together, not one of us building while the other observed. Both of us engaged. Both of us contributing to the decisions that shaped what it became. The technical direction decisions were led by Marcus. The application and market decisions were led by me. But those categories overlap constantly, because technical decisions have application consequences, and application requirements have technical implications. The real work happened in the overlap, in the conversations where his depth and my understanding of the market collided and produced something neither of us would have arrived at independently. That overlap was documented thoroughly. Not because we anticipated needing documentation, because we were careful people who communicated in writing and kept records of what had been decided and why. Emails exchanged across 2 years. Design files with version histories showing the development of each element. Meeting notes recording the decisions made at each stage. The accumulation of documentation that careful work produces when two people are building something seriously. We had no idea how important that accumulation would become. By the end of year one, we had something that worked. Not perfectly, not at the standard we knew it needed to reach, but demonstrably functional in the way that matters at that stage. Proof that the concept was real, that the technical approach was sound, that the application hypothesis was correct. The second year was the year of refinement, taking something that worked and making it work well enough to be genuinely valuable to the clients it was designed to serve. That year was harder than the first, not because the work was more difficult technically, because the standard it needed to meet was higher, because the distance between functional and excellent is longer and less certain than the distance between nothing and functional. We worked through it with the sustained commitment of two people who had invested too much to stop and who genuinely believed in what they were building. By the time I left for the family emergency, the product was close. Not finished, but close enough that both of us could see the end of the development phase for where we were standing. I told Marcus I needed to step away. He said he understood, that he would hold things together, that when I came back, we would be ready for the final push. I believed him. I had no reason not to. We had spent 2 years building something together, and everything about the partnership had told me that what he said he meant. I was wrong, but I didn't know that yet. The family emergency kept me away for 5 weeks. Not a planned absence. Not something I had prepared the business for in any structured way. Just the sudden necessity of being somewhere else entirely. Doing the only thing that mattered in that period, which had nothing to do with the product or the company or anything we had been building. Marcus and I communicated during those 5 weeks. Not frequently. Occasionally. Brief updates. He said things were moving, that he was working through some of the remaining technical elements, that I shouldn't worry about anything on the business side, that when I came back, we would be in good shape. I received those messages the way you receive reassurance when you are managing something difficult and need the other parts of your life to be held steady. With gratitude, without examination, because examination requires attention and my attention was entirely elsewhere. I came back in the 5th week, returned to the work with the specific focus of someone who has been away from something important and is ready to be fully present again. Marcus was normal, engaged, the same partner I had left. We picked up where we had been. The final development push began. Nothing in the first days back indicated that anything had changed. Nothing in how Marcus spoke or worked or engaged with me, or the product suggested that anything significant had happened during my absence. The legal check happened 3 weeks after my return, not triggered by suspicion, by schedule. We had a rhythm of periodic IP reviews, standard practice for anyone developing proprietary technology. The kind of administrative discipline that protects what you are building without requiring a specific reason to be vigilant. I ran through the portfolio and found it. A patent filing. Our product. 6 weeks earlier. Marcus's name. His alone. I looked at the filing details carefully. The date. The description of the invention. The claim structure. All of it describing what we had built together. In exact terms that told me the person who wrote the filing understood the product deeply. Which of course he did. He had spent 2 years building alongside me. The description was accurate. The claims were well constructed. The filing was professionally done, none of which had any legitimate explanation for why it carried only his name. I called him immediately, not because I expected a satisfying answer, because the conversation needed to happen before I did anything else. He answered on the second ring. I told him I had found the patent filing, asked him to explain it. The explanation arrived quickly, too quickly, in a specific way that prepared explanations arrive when the person delivering them has been waiting for the question. He said it had been administrative, that he had been working with a patent attorney during my absence, that the filing had been done in his personal name as a temporary measure, that he had always intended to transfer it to the company once I was back, that it was standard practice in some situations to file personally first and assign to the company afterward, that there was nothing concerning about it, that I shouldn't read anything into it. The explanation was plausible in structure, in the way that prepared explanations are always plausible in structure. But there are things it didn't account for. Why he hadn't mentioned the filing at any point in the 5 weeks I was away, or in the 3 weeks since I had returned. Why a transfer to the company had not already been initiated if it was always the plan. Why the filing described the full product rather than any element that could be argued was his independent contribution. Why the co-founder agreement's explicit IP ownership clause had not simply been followed from the beginning. I noted each of those questions without asking them on the call, because asking them would have told Marcus exactly what I was thinking, and told him how much time he had before I acted. I said I understood, that I would look into the standard practice he had described, that I was sure it would make sense once I had reviewed it. He said, of course. Said he would send me the attorney's details if that would help. I said that would be useful. Thanked him, and ended the call. Then I sat at my desk for a long moment, looking at the filing details still open on my screen. 2 years of joint work, described in a document bearing one name, filed during the specific window when the other partner was absent and occupied with something that had nothing to do with this. The administrative explanation was not credible. It had never been credible. It had simply been the explanation available to a man who had been asked a question he knew was coming, and who had prepared for it accordingly. I closed the screen and called my lawyer. My lawyer was a man named Mr. Souza. He had handled the company's legal work from the beginning, had drafted the co-founder agreement, had been involved in the early IP strategy discussions, which meant he understood the context of what I was describing before I had finished describing it. He asked me to send the filing details immediately. I sent them while we were still on the call. He reviewed them in real time, asked a few specific questions about the timeline, about whether Marcus had mentioned the filing at any point before I found it, about the specific language in the co-founder agreement's IP clause. I answered each one. He was quiet for a moment. Then he said what I had suspected, but needed a lawyer to confirm. The filing was not administrative. It was deliberate, and it was significant. A patent filed in an individual's name gives that individual personal ownership of the intellectual property described in the filing. Not temporary ownership pending transfer. Actual legal ownership. The transfer to the company would require Marcus to voluntarily execute that transfer, which he had not done, which he had shown no documented intention of doing, and which he was not legally obligated to do simply because a co-founder agreement said the IP belonged to the company. Because the co-founder agreement was a contract between the founders, and contracts bind the parties to them. They do not automatically supersede a patent filing made in a different legal context. The patent gave Marcus personal ownership of the core intellectual property. The co-founder agreement said that ownership belonged to the company. Those two things were in direct conflict. Resolving that conflict required either Marcus's voluntary action or legal compulsion. And legal compulsion required a process. Mr. Souza said the case for challenging the filing was strong, but that strong was not the same as simple or quick. Patent challenges are substantive legal proceedings. They require evidence. They require the clear establishment of joint inventorship. They require the invalidation of the individual filing on grounds that can withstand scrutiny. He asked about documentation, about what existed to demonstrate joint development. I told him about the emails, 2 years of them, exchanged throughout the development process, documenting decisions, directions, revisions, disagreements, resolutions. The full conversation of two people building something together. The design files, version histories showing the development of each element. Both our fingerprints on the work at every stage. The meeting notes, the records of decisions made jointly. The witnesses, our early development team, people who had been present for the work, who had watched both of us contribute to what the product became. Mr. Souza said the documentation was exceptional, that he had handled IP disputes with significantly less to work with. that what I was describing was the kind of evidentiary foundation that makes the difference between a challenge that is viable and one that is compelling. He said the joint inventorship argument was strong. Patent law requires that a patent accurately reflect who invented the thing being protected. A patent filed in the name of one person that describes an invention jointly developed by two people is not accurate, and inaccurate patents can be challenged and invalidated. The challenge would require establishing clearly and specifically what my contribution to the invention had been. Not generally, specifically, which elements of the patented claims were developed through my input, which decisions reflected my understanding of the application requirements, which technical directions had emerged from conversations between us rather than from Marcus's independent thinking. The documentation made that specific case possible because it didn't just show that I had been involved. It showed what I had contributed at each stage. The emails contained the actual conversations, the actual questions I had raised, the actual directions I had suggested, the actual problems I had identified that had shaped the technical responses. All of it time-stamped, all of it in the normal language of two people working on something together. Not constructed for a legal purpose, just the natural record of genuine collaboration. Mr. Souza said he would begin preparing the challenge immediately, that the documentation would anchor every element of it, that Marcus's position was weaker than he might have calculated when he filed. I asked about Marcus's role going forward while the process ran. Mr. Souza said that was a separate question, that the legal challenge addressed the patent, that the co-founder relationship was a different matter that would need to be addressed through the company's governance framework, that both needed to be handled, but carefully and in the right sequence. He said the first step was preserving the documentation. Every email, every file, every record, secured and backed up before anything was said to Marcus about the legal action, before Marcus had any reason to believe the challenge was coming. I went home that evening and secured everything. Copies made, stored in locations Marcus had no access to. The foundation of the case protected before a single move was made. Then I went to bed and thought about 2 years of genuine partnership and what it meant that the person I had built it with had spent my absence doing what he had done. The legal challenge was filed without warning to Marcus. Mr. Souza had advised that approach specifically. Any advance notice would give Marcus time to prepare a counter-narrative, to consult with his own legal team about how to frame his position before the challenge landed, to potentially take steps that complicated the process. Better to file and let the filing be his notification. Let the formal legal document be the first indication that what he had done was being challenged seriously. I agreed. The filing happened on a Thursday morning. Mr. Souza confirmed it was submitted. I went about my Thursday, the same deliberate normalcy I had maintained throughout every other difficult situation in this story. The business continued. The work continued. The product development that had been the purpose of everything continued, because the legal process would take the time it took, and allowing it to consume the foreground of my professional life would serve nothing. Marcus called that afternoon, within hours of the challenge being filed. His tone was different from every previous call. The composed professional manner that had characterized our interactions since my return was gone, replaced by something with more edges in it. He said he had received the legal papers, said he wanted to discuss it directly, that there had been a misunderstanding, that the filing had always been intended as temporary, that there was no need for legal proceedings, that we could resolve this between ourselves. I told him the matter was now in the hands of my legal representative, that I would ask him to direct any communications to Mr. Souza, that I was not in a position to have a direct conversation about the subject of active legal proceedings. He pushed, said the legal route was unnecessary, that would damage the company, that would damage both of us, that we had built something together, and this was not how partners resolve disagreements. I noted the irony of that last point without saying so, told him again to contact Mr. Souza, and ended the call. The legal process that followed was not fast. Patent challenges operate on their own timeline, thorough rather than urgent, each stage requiring the preparation and submission of specific documentation, each submission requiring response from the other side. The process moving through its stages with a measured pace of something designed to arrive at accurate conclusions rather than quick ones. Marcus retained a patent attorney. His position was the administrative explanation, that the filing had been a temporary measure, that he had intended to transfer it to the company, that the challenge was therefore premature and unnecessary. His attorney presented that position with professional competence. Mr. Sousa's response was the documentation. Every email, every design file with its version history, every meeting note, every piece of the 2-year record that established joint development clearly and specifically, submitted systematically, with a narrative that connected each piece to the specific claims in the patent, showing precisely which elements of the patented invention had been developed through my contribution, not generally, with the specificity the process required. This email documents the conversation in which the application requirement was defined. This design file shows the version that incorporated the structural change proposed in that conversation. This witness account describes the meeting in which both founders were present when the critical technical direction was decided. Each element of the joint inventorship argument grounded in specific documentation. The witness accounts were significant. Mr. Sousa had spoken to the early development team members, 3 people who had been present during key stages of the development process, who had watched both of us working on the product, who could speak specifically to what they had observed about each person's contribution. Their accounts were consistent, not identical in phrasing, consistent in substance, the way truthful accounts from independent witnesses are consistent, each of them describing the same collaborative process from their own vantage point, each of them confirming that the product had been developed jointly, that both founders had contributed substantially and specifically to what it became. Marcus's attorney challenged the witness accounts, suggested their recollections were influenced by their relationship with me, that they were employees or former employees with an interest in the outcome. Mr. Sousa addressed the challenge directly. The witnesses had no financial interest in the outcome. Their accounts were consistent with contemporaneous documentation created before any legal dispute existed. The challenge to their credibility was not supported by anything substantive. It was the challenge available to a party whose own documentary record was significantly weaker than their opponents. I want to describe something about the period the legal process ran through, because it required a specific kind of discipline that I want to be honest about. Marcus and I were still nominally co-founders throughout most of it, still both technically associated with the company, still both nominally involved in the business, even as the legal process made normal collaboration impossible. Managing that situation required keeping the two things genuinely separate. The company's operations were not going to wait for the legal process to conclude. The product still needed to reach completion. The business still needed to function. I managed it by being clear with the team about the situation in the terms I could be clear about, that there was a legal matter running, that would not affect their work or the company's direction, that I would keep them informed as the situation allowed. And then I kept the operational leadership of the company moving as if the legal background was not the foreground of my attention. Because it wasn't. The legal process was running correctly in the right hands. My attention belonged to the work. The patent challenge proceeded through its stages over several months, each stage producing the same result. The documentation holding. The joint inventorship argument standing firmly against each challenge Marcus's attorney brought. The specific and contemporaneous record of 2 years of collaborative development doing exactly what Mr. Sousa had said it would do, making the case compelling rather than merely viable. Marcus's position eroded as the process continued, not dramatically, incrementally, the way a position erodes when it is built on an explanation rather than on facts. The administrative error explanation had never been strong. It had been the explanation available to someone who needed to say something when confronted. But explanations don't improve under scrutiny. They degrade, because scrutiny asks questions the explanation wasn't designed to answer. Why had no transfer been initiated in the 3 weeks after my return before I found the filing? Why had no mention of the filing been made to me at any point during my absence or after my return? Why had the patent attorney been engaged during the specific window when I was away and occupied with a family emergency? Why did the filing describe the complete product rather than any element that could be argued as Marcus's independent contribution? Each of those questions had no comfortable answer within the administrative error framing, because the administrative error framing was not the truth, and the truth had a shape that the documentation showed clearly. Marcus had seen an opportunity during my absence, had acted on it quickly, had retained a patent attorney within the first weeks of my being away, had filed a comprehensive patent on the jointly developed product before I returned, had prepared an explanation for when I found it, and had spent 3 weeks after my return waiting for that moment. The deliberateness of the timeline was visible in the documentation, not as inference, as sequence. The dates told the story without editorial. Patent attorney engaged in week 2 of my absence. Filing submitted in week 4. I returned in week 5. 3 weeks passed without disclosure. Routine legal check found the filing. Call made. Explanation delivered immediately. The sequence did not describe an administrative error. It described a plan that had been executing precisely until the routine check disrupted it. Mr. Souza presented the timeline as a core element of the challenge, not the only element, an element that worked in concert with the documentation of joint development to produce a picture that was difficult to explain away, because it answered the question of intent, which the administrative error explanation needed to address and could not address convincingly. The challenge process produced its finding. The patent was invalidated. The filing had inaccurately described sole inventorship for an invention that had been jointly developed. The documentation of joint development was clear and substantial. The timeline of the filing was inconsistent with the explanation offered. The patent could not stand in the form filed. It was invalidated. I read the finding in Mr. Sousa's office. He walked me through the specific language, the legal basis for each element of the finding, what it meant practically. I asked what happened next. He said 2 things. The patent was gone, which meant the IP question was resolved. The product's intellectual property now needed to be properly filed in the company's name, which we would do immediately and correctly. And the co-founder relationship needed to be addressed, because a co-founder who had attempted to personally patent jointly developed intellectual property was a co-founder whose relationship with the company was no longer sustainable. The co-founder agreement contained provisions for this. Circumstances under which a founder's stake could be addressed following a material breach of the agreement. The patent filing constituted a material breach. The finding had established that the filing had been inaccurate. The co-founder agreement's IP clause had been violated. Mr. Souza said the grounds for addressing Marcus's position in the company were clear, that the process would require careful handling, but that the legal foundation was solid. I told him to proceed. He began preparing the documentation for the co-founder separation. I went back to the office, sat at my desk, and thought about what the next conversation with Marcus was going to require. Not from an angry place, from a clear one. The legal process had produced the correct finding. The documentation had done what it needed to do. The patent was gone. The IP was recoverable. What remained was the relationship, and the relationship had to end. Not because I needed it to end for emotional reasons, because the company could not function with a co-founder whose conduct had demonstrated so clearly that his interests and the company's interests had separated. That is a specific and practical reality, separate from the personal dimension of it. A company cannot be led by people whose fundamental alignment with its purpose cannot be trusted. And trust, once broken in the specific way Marcus had broken it, does not simply reconstitute because a legal process has run its course. The separation would happen, The question was how cleanly it could be done. The conversation with Marcus happened in the office. His choice of location as it had been in the Raymond situation, though the parallel ends there. Because Marcus arrived at that conversation in a different position from anyone in any of the previous situations. He arrived as someone who had just watched a legal process invalidate something he had constructed deliberately, who understood that the documentation he had underestimated had produced the finding he had been hoping wouldn't come, who knew that the conversation we were about to have had only one realistic conclusion. He was composed. I will give him that. The particular composure of someone who has processed their situation privately and arrived at the meeting having already made their peace with the direction it was going. He sat down. We looked at each other across the table. Two people who had spent 2 years building something together, who had shared the particular intimacy of genuine collaboration, of combined effort toward a shared goal, of the specific trust that forms between people who are working on something real, and who had arrived at this. I started by acknowledging what the 2 years had been, not as a preamble designed to soften what was coming, because it was true, and truth deserved to be said first. The partnership had been genuine. The collaboration had been real. What we had built together had required both of us. None of that was undone by what he had done during my absence. It was complicated by it, permanently, but not erased. He listened without interrupting. Then he said something I had not expected. He said he had known when he filed it that it was wrong. Not a misjudgment, not an administrative decision that had been poorly executed. A choice, made in the specific window my absence had opened, with the specific calculation that the product was close enough to completion that controlling the IP personally was worth attempting. That if the filing was not discovered immediately, the transfer to the company could be managed on his terms. That if it was discovered, the administrative explanation would provide enough cover to negotiate from. He said it without embellishment, with the particular flatness of someone who has been through enough of a legal process to understand that performance is no longer useful. I received it the same way, noted it, did not respond to it emotionally, said that I appreciated him saying it directly, that it made the conversation simpler. Then I told him where things stood. The co-founder agreement's breach provisions applied. His stake in the company would be addressed according to those provisions, not at the current valuation. At the valuation methodology, the breach provision specified, which reflected the company's position at the point of the breach rather than its current position. He nodded, asked one question, whether there was any path to a different outcome. I told him honestly, no, not because I needed to punish him, because the company needed to move forward with leadership whose alignment with its purpose was not in question. And his alignment was now in question in a way that could not be unquestioned by anything he said or did from this point. He nodded again, said he understood. We concluded the meeting. Mr. Souza managed the formal separation process over the following weeks. The co-founder agreement's breach provisions were applied exactly as written. Marcus received what the provisions specified. The valuation methodology produced a number that reflected the company at the point he had chosen to act against it, not the company it had become through the completion of the product he had tried to take. He accepted the terms, signed the documentation, departed cleanly, without a prolonged process, without secondary legal action, with the particular resignation of someone who had gambled and understood the outcome of the gamble clearly. The product was filed correctly in the company's name within the week following his departure. Mr. Souza handled the filing personally. Every inventor listed accurately. Every claim properly attributed. The documentation of joint development used to support the filing correctly rather than a challenge one filed incorrectly. The IP that had been the subject of the entire preceding process now sat exactly where the co-founder agreement had always said it belonged. In the company, cleanly, without ambiguity, without anyone's personal name on something that had never been theirs alone. I want to say something about the product itself, because through all of it the product had continued to develop. The work had not stopped. The team had continued. The final stages of development that Marcus and I had been approaching when I left for the family emergency had been completed, not by me alone, by the team, with my direction, moving toward the completion that 2 years of work had been pointing toward. The product launched about 4 months after Marcus's departure, not to fanfare, to the clients we had identified as the right early adopters, the people whose problems it was designed to solve, who found it exactly what we had built it to be, something that worked, something that addressed a genuine need in a way that nothing else was addressing it. The reception was what good work receives when it reaches the right hands. Not immediate universal acclaim, specific and genuine appreciation from people who understood exactly what they were looking at, and the quiet beginning of the reputation that follows genuine utility. I think about Marcus sometimes, with less anger than might be expected given what he did. What I feel most is the specific sadness of genuine talent directed at the wrong thing. He had been a real partner for most of the time we worked together. The technical depth that had made the partnership work had been real. The contribution he had made to the product had been real. All of that existed, and he had chosen to risk it, to risk the partnership and the company and the 2 years of shared work, for personal ownership of something that had never been only his. The choice was incomprehensible to me at the time. I understand it somewhat better now. Not excuse it, understand it. Fear is often behind these decisions. The fear of what happens to the value you have created if the partnership breaks down for reasons outside your control. The specific anxiety of someone who has built something valuable in collaboration with another person and who begins to wonder what happens to their share of it if the collaboration ends. That fear is understandable. Acting on it the way he acted is not. Because the correct response to that fear is conversation. A direct discussion about what both parties need from the arrangement going forward, about how the IP is protected, about what the partnership structure looks like as the product nears completion, about what each person's stake in the outcome is and how it is secured. He could have had that conversation with me at any point in the 6 months before my absence, or during the month I was away, or in the 3 weeks after I returned. He had opportunities. He chose differently, and the documentation I had been building for 2 years made sure that choice cost him exactly what it deserved to cost. The company is mine now, entirely. The product is protected correctly. The team is focused on what comes next. The foundation is sound, built from 2 years of genuine work and protected by the documentation that were produced. That documentation had not been created to protect anything. It had simply existed because careful work leaves careful records, and careful records turned out to be exactly what the situation required. That is the part one think about most when I reflect on everything that happened. Not the legal victory, not Marcus's departure, the 2 years of ordinary careful documentation, the emails exchanged in a normal flow of collaboration, the files saved with version histories, the meeting notes taken as a matter of habit, none of it created with any awareness that it would one day constitute the evidence that protected everything. All of it created simply because that is how careful people work. And careful work, it turned out, was its own protection. Before I knew I needed protecting. The most powerful evidence you will ever have is the record of work done honestly over time. Because no one can manufacture 2 years of genuine collaboration after the fact. If this story resonated with you, the documentation, the patience, the quiet protection of careful work, leave it in the comments. I read every one, and the next story is already waiting for you.